join us in what we hope will be a really informative presentation on IP aspects of AI as applied to businesses across industries. So no matter what industry you're in, hopefully you'll get some pointers from this presentation that you can put to immediate use. A little bit about our firm, for those of you who aren't familiar with us already. We are that's Norris McLaughlin. We're 120 attorneys. We have 3 offices. David and I, Siegel and I, are partners in the intellectual property department and resident in our New York City office. We also have a Somerville, New Jersey office and an Allentown, Pennsylvania office. Our IP practice is pretty much exclusively in the New York City office, and we are experts in patent, trademark, and copyright, prosecution, enforcement, litigation, pretty much transactions, due diligence in connection with combinations or mergers and acquisitions. So pretty much everything in relation to IP. And in addition, we are privileged to have a full range of legal services so that we can serve virtually every legal need across our real estate, business law, tax law, estate planning law, and commercial litigation and insurance and collection. We have wide array of practices. So just because I didn't mention it doesn't mean we don't do it. And we encourage you to check us out further. All right, so without further ado, David and I are going to begin. As I mentioned, I'm delighted to have David's help. David is got a technical background in engineering, and that will help us to learn more about the technical side of AI, but in a way that everybody should be able to understand. And if we go to the next slide, I can give you a little bit of an overview of what we're going to be discussing, and then turn it over to David for roughly the first half of the presentation, and then I'll take over. While either of us is talking, the other person will be monitoring the Q&A chat at the bottom of the screen. We are going to go the full hour because we have a lot we want to share with you, so we're not going to have time to take questions. But if you drop them into the Q&A box, we'll monitor them, and if one comes up that's relevant to what the other person is saying, that person will alert the speaker, and the speaker will answer questions. In addition, at the end of the presentation, our contact information is listed along with our LinkedIn profile QR codes. And so you can contact us ideally by email if you have any questions after the presentation that you didn't get a chance to ask or that weren't answered to your satisfaction during the presentation. So we're going to begin by defining intellectual property, just some basic concepts around what copyrights, trademarks, patents, and trade secrets actually are and what they protect. Then David will be covering that, and David will also be covering key terms in AI. So these really technical terms, he's going to explain in an easy to understand way. Then I'm going to be talking about the common use cases for AI in business, and then what specific challenges are presented from a legal standpoint, and particular an IP standpoint in relation to these use cases. And finally, I'm going to wrap up with best practices for using AI. And throughout, I'm going to be alluding to what you can do to maximize the potential of AI while mitigating the legal risks associated with it. All right, so without further ado, we'll go to the next slide, and David will begin.
Hi, so nice to meet you all. My name is David Siegel. Thanks, Gene, for the introduction. So I want to talk first about what is IP, intellectual property. Broadly speaking, we talk about IP. They're these sort of intangible products of human creativity and ingenuity. They break down, we talk about the tripod usually, which are patent, trademark, and copyright. We also want to talk about trade secrets, which matter too. So patents covers in the US 3 different things, one of which sometimes treated differently abroad. Utility patents, which are the most common and best known, which protect inventions. either new created things or ways of doing things, a new machine, a new manufacturing technique, a new medical treatment technique, a new chemical, etc. Their design patents, which have been growing in importance in recent years, those are the visual and ornamental design applied to an object of manufacture. So when you see a car or a shoe, the appearance of it, the silhouette, the markings on it are often due to design patent protection. And then there's sort of the one everyone forgets, which are plant patents, which are very specifically plants which are capable of reproduction from cuttings or buds are protected by patents if you have a new variety. Interestingly, some plants can in fact be subject to utility patents. That's not really relevant to what we're talking about today, but it's interesting. When we come to AI, there's of course the patents in the AI technology itself. And more importantly, for every business who might use AI in their creative or development process, there are open questions regarding how much AI input is permissible in something that's still protectable as an invention by patent. Next slide, please. Trademarks are sort of my favorite. They are anything that can indicate the source of a good or service. So most famously, words or logos, the name Nike, the name Disney, those are trademarks. Then there are logos, like the Nike swoosh is my favorite example of that. But it can be anything. It can be a color, a shape, a sound, Tiffany blue box, shape of Coca-Cola bottle, or the NBC chimes, the sound of someone saying, "Let's get ready to rumble," is a particular trademark. And there are even stranger things. There are smells. There are, my favorite strange one is there's a hotel which has a trademark on a ritual with ducks they do every afternoon. So what makes a trademark? A trademark is anything that you can perceive that tells you it came from a particular source or producer. You look at something, you go, well, I know that this shoe is a Nike because there's a swoosh on it. Or I know this shoe is a Nike because it says Air Jordan on it, etc. Again, in the AI context, a lot of people are using AI to develop branding materials, saying, I want a new logo. Let's see what AI gives me as a logo. On the flip side, there's also, because of what I'll get into later about the training sets, a lot of especially generative AI for images will give you things that include trademarks. So if you ask for an image of a coffee shop, there's a significant possibility it's going to include Starbucks branding. Next slide, please. Copyrights are in the Constitution, and they are sort of the most relevant for AI. They are the collection of rights to do something with any creative work, to display it, distribute it, copy it, perform things that are performable, make derivative works of it, etc. You can slice these up. You can say, I'm going to give you the right to reproduce, but not the right to distribute, the right to distribute, but not the right to reproduce, the right to broadcast, but not reproduce otherwise. Slice it up by time, by portion. This is the next slide, please. This is the type of right that protects movies, books, music, sculpture, test questions, maps. Anything that is fixed, written down, recorded, put into a sculpture that is a human creation and is original is protected to at least some extent by copyright. There's been some expansion in recent years of what copyright can cover. There's a boundary about something called useful articles as opposed to creative expression. That line's moved somewhat in recent years. This is the big one for AI. Both things you generate with AI, there's an issue with, are they protected by copyright? And when you use AI to generate something, there's the question of, are you infringing someone's copyright? And that's going to be sort of one of the major questions we talk about here and whenever you deal with AI in the business context. Next slide, please. Trade secrets are sort of a later emergence. They were for a long time purely creature of state law. There's now federal law protecting them. They are anything that is secret, that is valuable to business because it is secret. Most famously, anything that you use in manufacture, in your manufacturing products that isn't publicly known. So Coca-Cola, the recipe for Coca-Cola is a trade secret. It's not patented, but anything that you make an effort to keep secret and is valuable because it is secret, you have a bundle of rights around it to be able to protect it. So if someone discloses it, or if someone discovers it in a manner that violates your rights, you can prevent them from using it, prevent them from further disclosing to other people. Again, in trade secrets, there's a big risk that if you're using AI in your business, there's a possibility that if you're telling it trade secrets, there's an issue of leakage, which you'll get into later, because if it's not an entirely internal AI system, who's getting it? Who are you telling it to? Who might it leak to? Next slide, please. Broadly, I mentioned some of these before, but there's broadly two places where you got to worry about IP in AI. The first is anytime you're using any kind of AI, if you're putting your IP into a system that is not completely under your control, there's a question of, is it going to get out? Is it going to be seen by someone else, used by someone else? Then there's the other end of it, which is if you're using AI that generates any content or does anything, is that output infringing a third party's right? And I'm going to be covering that a little bit more, and Jean will take it from there. Next slide, please. So let's talk about, now that we've talked about what IP is, let's talk about what AI is. AI goes back 70 years to the sort of dawn of computer science as a discipline. It's the science and engineering of making intelligent machines. For a very long time, this meant just writing a program that acted like we thought people thought. So things that would play games, they would play checkers or chess or tic-tac-toe even. And rather than saying, do this move, they would analyze the board state and make a decision based on it. And for a very long time, it was literally someone would hard code. They would say how the decision is made, and that was AI for a long time. Later on, something called machine learning developed, where you say, rather than writing a program that's going to act in a way that we believe is like thought, let's just make a program that learns how to do something. So a program that you play chess with it, it gets better at chess. Pretty much everything when we talk about AI nowadays is a machine learning system. And then within machine learning, we talk about deep learning, which relies on big data. We're looking at huge amounts of data and then training on that. And then the sort of newest thing, which is getting all the attention right now, is what's called generative AI, which is rather than simply making a decision or identifying something, saying, yes, that is a picture of a cat, or saying, adjust the temperature of this manufacturing process or this cooking tool based on the following 16 inputs and the curve that it's learned how to make better rice. It actually generates content, images, text, video, voice, etc. Next slide, please. This is sort of a map of the many, many things that get called variously AI. Anytime a computer analyzes an image, that's broadly speaking AI. Everything goes into any kind of robotics, broadly speaking AI. But we're mostly going to be talking about, on the left side here, machine learning and generative AI under types of AI. I want to distinguish, it's very important to distinguish between, next slide, please, AI more broadly and generative AI. For a very long time, AI was already making decisions or doing analysis for people. For example, if you have a rice cooker at home that costs more than about $20, you have something called probably a fuzzy logic rice cooker, which rather than just saying, based on the temperature of the vessel, the rice is done, it says, based on the way the temperature has been rising and the temperature of the room and the steam output, multiple variables, it's going to adjust the cook time and the temperature to make perfect rice. So in your home for 35 years, there's been AI. Every camera that does autofocus, that's fundamentally an AI system. We see a lot of these for like facial detection, learns to recognize you, or voice detection, dictation systems that have improved substantially over the past 20 years, or that get better for your voice versus someone else's. That's a learning system. There's a whole universe of these that you may wind up using in your business for process control, for especially medicine. There's cancer detecting AI that's getting very good very quickly. But the AI that's getting all the news, that all the vendors are trying to sell everybody all at once, that when you do a web search now, you get an AI result first, that's generative AI. That's what we're talking about the most. That's the sort of biggest exposure right now because people are working to plug it into every aspect of business and find use cases for it everywhere. Next slide, please. This is a fun little image because AI has been with us for a very long time. As I said, 70 years, people have been working on it. Chess playing programs from 30 years ago, 20 years ago that you have on your home computer, the autocorrect in your phone, those are all AI. Generative AI is this sort of, I don't want to call it the fresh new thing, but it's 10, 15 years old at the oldest. Really, the past 5, we've seen the big jumps forward. And they're the ones that people are treating as a very new and very highly capable system for generating content, for making decisions. People consult it for all sorts of decisions. And it poses significant issues for every business, particularly in the AI space. Next slide, please. So let's talk about definitions. The most important term probably for most modern AI and machine learning is something called a neural network. The way a neural network works is there are a series of artificial neurons based on an understanding of how neurons in the brain work. And they can be weighted and reweighted. So the way it works is you build a neural network, and initially you don't have weights or you have starting weights, and you give it some input, and then it, using the weights in that neural network, generates an output. And if the output is right, you strengthen the weights that led to that. If the output is wrong, you weaken the weights. And over time, and very quickly sometimes, you can change the weights of the internal processes so that the neural network gives the right answer. Neural networks got very good very quickly at recognizing anything that could be input to them. So probably 20 years, 15 years ago, almost more than that now, you could put an image into a computer, and 25 years ago, the computer could find the edges. 20 years ago, it could find a face. 15 years ago, to recognize a face. It could say there's 5 cats in this image. It could say that's a dog versus that's a cat. And then it can recognize whose face it is. That's all neural network based. What came out of the neural network is something called the generative adversarial network, where you take 2 neural networks and you say one of them is trained to recognize an input, and you take the second one, and this is the part that is sort of underlying a lot of this, is the second, you will train the second network using the first network. So let's take cats, for instance. You take a huge group of images of cats, pictures of cats in them, and you train a first neural network to recognize when there's a cat in image. And then you take a second neural network that's untrained, and you use it to generate random images. And then you basically train that second network based on the response of the first. So if a random image it generates, it says there's no cat there, that's not a good image. If it says, well, maybe there's a cat there, better image. First one says there's definitely a cat there, that's an image that you want to make more of. And over time, you can now train that second neural network to generate pictures of cats. Next image, please. There are more complicated models. One of them is called a diffusion model, and this is used for generating something. It's sort of what we just talked about, where getting from random to specific, but it's trained in one chunk. You basically say, let's figure out a mathematical equation that gets from the random set of randomly distributed images or texts or sounds to a specific group of images, and then run that backwards. It's a lot more complicated than that. It uses techniques that come out of astrophysics and gas dynamics. That's what I call the diffusion model. But it's actually very powerful for generating things like images or arbitrary texts. Now, the most powerful at this time are what are called transformer models. These are neural networks which have internal structures that let them look backwards across layers in their own model to generate extremely long form text or extremely complex images. So rather than just saying, well, what's the next word here? They can say, I've got a 6-word phrase, next word. Okay, but 6-word phrase, 20-word phrase, 2-paragraph phrase, next word, next sentence, next paragraph. Next page, please. So we have some of this. Now we can talk about what the most famous group of generative AI models are, which is the GPT class of models created by OpenAI, GPT-4, ChatGPT, Conmigo runs on this. It's generative. It creates content rather than just recognizing something. It's a transformer, so it's able to generate significantly large inputs and outputs by looking ahead and back in them at once. And it's pre-trained. We'll talk about training in a second, but pre-trained means before you train it to do a specific thing, you just feed it a huge amount of data, either text or images, or in some cases both. So it has a lot of internal linkages about how things go together. You know what words come after what other words, how sentences sort of are structured, etc. Next slide, please. Generative AI is where we are, what all those things are. They started out with running recognition AI backwards. About 10 years ago now, Google Deep Dream, which was one of the first things to really generate images that looked sort of convincing. They were actually sort of horrifying images, because what it did was it said, okay, we have this AI that can look at an image and recognize there's a dog or a cat in it, which means that it has some concept of what a dog or cat is. So we're able to generate dog images that at first were horrifying monstrosities with 3 heads and 19 eyes, but were recognizable as having dog in them. And over time, those got better and better. ChatGPT, which is sort of the first major model of the modern generative AI generation, is now coming up on 2.5 years old, which is an age, forever in this context. It works. There's text. You can do text input output, image input output, audio, video. They can generate video. You can give it text, it generates video. You can give it a video and it generates a significant text summary of it. Next page, please. All of this comes down to training, because these are all pre-trained models. They're all fed images or text or audio or video, and based on what they're fed, they generate things. There's a concept in computer science called garbage in, garbage out, GIGO. At the end of the day, no system can be better than its input. So if something is trained entirely on nonsense input, it can only ever output nonsense. This is very important for both the IP question of use of AI and the reliability and value of AI. Because a lot of the AI companies, OpenAI, Meta, which is Facebook, Microsoft, they train on huge corpuses, which have two significant issues. One, they're not vetted for being accurate or true. And two, they contain works that are protected by copyright but weren't authorized for this use. So for very significant reasons, because they're just trained off the internet, they'll often lie to you. A lot of AI is trained on old scientific information, fiction, conspiracy theories, racist content. Every so often you'll see going around someone asking Google a question and the AI summary, including things like, it's recommended that pregnant women smoke 6 to 8 cigarettes a day for the health of the baby, because someone made a joke on Reddit 15 years ago, and that got included in the training set, and now here we are. The other issue is a lot of these include, like much of the internet, copyrighted content that was outright pirated or wasn't authorized for this use. Most significantly, Meta recently admitted that it used a database called LibGen, which is a database of millions of of books and papers, a lot of them copyright protected, that were just online. And Meta used that to train its AI, which means that you hear about authors of fiction saying, yeah, my 12 novel series about magic and knights was used to train this AI that people are now asking questions about, which means the AI, first of all, knows about magic and knights, which isn't real, and it can't tell them between real and fiction. And two, that's my copyrighted content that it might be able to spit back out. Next slide, please. There are two major issues that arise from this training problem. One is hallucination, which is it will either say things that aren't true because things that aren't true were in its data set, and more significantly, because they're trained to generate things that seem correct and not are correct, they will answer your questions in the affirmative because you're more likely to ask a question where the answer is yes than no. So they're biased towards answering yes. Famously, a lot of image classifiers and recognizers for years have done things like, they'll just say there's a giraffe somewhere. You show them a picture of a living room, there's a giraffe there. Show them a picture of an empty field of grass, ask if there's a giraffe, there's 2 giraffes there, they'll tell you. And then there's a new and ongoing problem called model collapse, which is because so much of the internet is now AI generated or AI modified, there's a problem like microphone feedback, where rather than being trained on actual human output, they're being trained on AI output. So they're drifting further and further away from both reality and what sounds normal to a human. Next slide, please. And this is that's me done, and it is now time for Jean to take over and talk about why this matters to you.
Thank you so much, David. So David's really set the table, and now I want to talk a little bit about common uses that you may make of AI in your business. As David intimated when he was discussing patentable inventions. You may be using AI to create new kinds of products or services. Maybe some of these would qualify for patent protection. Maybe some of them might be result in trade secrets. And so those are obvious cases where IP issues are implicated. Additionally, you might be using AI to generate advertising, promotional material, even brands and logos. And that is another instance in which you have an intersection of trademark law with AI. Obviously, because AI can intake huge amounts of data, it is a great predictive tool. It can quickly identify patterns and trends, and it can help you to increase the efficiency of your business and even determine if in reaching a particular business goal, you were cost effective and you used, the right people to achieve that goal. It can also, as everyone knows, automate repetitive tasks. This includes a lot of customer service type tasks. We've all been probably in touch with an AI agent when we've contacted Amazon or some other company that heavily deploys them. AI can also be used to optimize the workflow. Who do you assign projects to? Where should they go in terms of which teams or which divisions in your company should handle them and when? And the processes that you use to reach your desired result. Next slide, please. Supply chain management, a real big issue lately in the wake of the pandemic and other disruptions, is also an ideal AI use case. You can use AI to generate scientific discoveries all of the time in pharmaceutical development, for example, and cancer research. You can use it to interact with your employees for things like training and onboarding. You can use it to report your financial status to your investors or otherwise internally. And you can test the quality of your decision making and the how you arrived at a particular decision against an AI tool. You can also just organize information, vast amounts of information, and access it much more easily with AI. And as we may know, coders are using AI to generate lines of code, and it's actually replacing human beings, which is why there have been so many layoffs of coders at tech companies. Next slide. So there are two basic use cases that implicate IP. David intimated as to these. I'm going to expound upon them. First of all, is when you're inputting company data and processes into AI to achieve a business goal. So obviously, in that situation, you may be sharing information that is proprietary, even if it doesn't rise to the level of being a trade secret. It's information that you really don't want the world to know about. So that's the first situation in which you could run into trouble with leakage, as David mentioned. The second situation is when you're generating new content. And it can be to achieve a business goal. It can be to do any of those things that we talked about. And most particularly, this kind of content generation implicates the copyright laws in two ways. First of all, you may inadvertently be violating other people's rights and content because the AI tool indiscriminately scraped third-party intellectual property as part of its data set. And secondly, you may find yourself in a pickle when you're trying to enforce rights and content that you created. So that's the flip side, when you're actually trying to protect others from copying your work, because you may find that your human creation of that content falls short of what the Copyright Office and the copyright law require in order to protect exclusive rights. Let's turn to the next slide. So as a backdrop for all of this, it's important to understand that there is absolutely no federal regulation of AI in the United States. Congress has long shirked regulation of tech companies, and AI is no exception. I think many of them, quite honestly, could use a primer from David on this. They don't understand it, and they haven't attempted to understand it, and many of them never will. And as a result, they're not in a position to regulate it. And on top of that is that we have an administration that is currently very much taking an anti-regulatory approach across the board, and in particular with respect to tech, which the tech companies are rejoicing because they don't want to be regulated. They think it suppresses their ability to innovate and to compete in a really a global race to achieve AI dominance. But what this does is may help the tech companies and make it easier for them to innovate, but there are two victims, really. The first is, the creator of all of the content that is proprietary or protected under the IP laws. And the second is the private enterprise that wants to use AI, but really is kind of like faced with a buyer beware, caveat emptor situation, where it has to consider all of the risks in the absence of regulation and any kind of quality control, so to speak, of either the data sets or what the tools themselves are doing, and has to take on those risks themselves and do the kind of due diligence and hard work to make sure that it is not falling into any of the traps that this lack of regulation has led to. So the only laws really regulating AI at this point are at the state level. And these are the so-called deepfake laws, which evolved as a result of a lot of concocted political advertising and other images that faked people. So a politician might be faked and saying things that they never said. And so the states felt like it was important, especially during election years, to regulate that content and outlaw it. And then the other body of law at the state level that has developed legislatively are the non-consensual porn laws. And these have resulted from an unfortunate situation in which young people, typically young women, their faces are affixed to nude bodies, and it's terrible. And it really got out of control and non-consensual porn. Now, the other kind of enforcement that's happening with respect to AI can implicate federal law, but it's federal law that was not designed specifically with AI in mind. So these include like consumer protection laws and unfair competition laws, both at the state and federal level, that exist to help police deceptive content and the like. So that is another way that AI is being regulated. Now we can go to the next slide. Now, I'd like to just point out briefly, for those of you that are doing business at all in the EU, that the contrast between the US approach and the EU approach to AI regulation could not be more stark. The EU regulates heavily, and the tech industry believes, and may be right, that they regulate so heavily that they're actually suppressing innovation of AI, because AI is classified into 4 risk levels. The risk level is generally associated with the risk to the population, to individuals. That's minimal, limited, high, and prohibited. And generally speaking, the systems that are prohibited are the ones that infringe on individual rights of privacy, facial recognition, biometric measurement, belief systems, race, political opinions, all of these things AI could potentially track. And those kinds of systems are generally prohibited unless there's some sort of law enforcement purpose. In addition, and this is something maybe we could use, there is a requirement that artificially generated content be labeled as such, as where it's not quite obvious that it's artificial. And finally, there are these reporting requirements that AI models have to be tested, evaluated, tracked. Serious violations have to be reported, and there have to be sufficient cybersecurity protections built into them. So this is all unique to the EU, and none of it exists. So, in view of this regulatory framework, what is most important as you're considering using AI or already using AI in your business? Well, first of all, David mentioned that there was an issue of leakage, and that issue generally arises when the platform you're using is an open system, meaning that it trains on the data that everybody inputs into it without discrimination, and therefore all of that data is then subject to being output. So it's input, potentially by you, and then it could be output to somebody else. And this is where trade secret issues, proprietary information, confidential business information issues come to the forefront, because you do not want to be putting this kind of information to an open system in general, right? There are opt-outs. I remember looking for one on ChatGPT when I was using it in the early days, and it was very hard to find, and goodness knows, it works. It actually works. So better to use a closed system. The proprietary models are going to not be free, for one thing. You're going to have to pay for them, but they will assure you that if they're well designed, that the information that you input into them will stay in your own system. And we'll talk a little bit more about what to look for if you're contracting with a vendor to create such a proprietary tool, okay, in a little bit. So here are some examples of the ways that things can be leaked with an open AI platform. Copyrighted content or trade secrets, or even patentable inventions, or your logos or logos under development, or brands, promotional material, all can be used by third parties, maybe unwittingly, as to your own rights. So, just as David pointed out earlier, these tech companies are really not taking a conservative approach at all to what they're scraping. Quite the contrary, they're just breaking things, which is what they like to do, and worrying about it later. And so they're training on data sets that are not cleared for use. And as I'll talk about in a little while, that's resulted in a number of litigations. That is obviously going to directly impact you. You do not want to be the victim of an unwitting IP infringement by a third party. So we recommend using closed proprietary systems from reputable vendors that don't trade on data that you're inputting into the system that belongs to your business. Next slide. So let's turn to specific laws governing the IP laws that address AI. And so in some ways, the Patent Office and the Copyright Office have been better at dealing with this than Congress, because they recognize that they're directly impacted by AI, and so they have to address content or inventions that's created with use of AI. So the United States Patent Office has actually issued some guidance on the patentability of inventions created with AI. First of all, there's some obligation to disclose whether AI is used in the innovation process. So if you're actually using AI to generate the ideas that form the basis for the invention, it may be necessary to disclose that to the Patent Office when applying. But if you're using AI perhaps to refine ideas that you had or your company had, then there is no affirmative obligation to disclose. And I have linked here, if you are interested, to the Federal Register publication of inventorship guidance for AI-assisted inventions. The PowerPoint will be made available to you to attend, so you'll do that. But the bottom line is that AI-assisted inventions are not categorically unpatentable. They can be patented, but the human being has to make a quote unquote not insignificant contribution to the invention. What does that mean? That is going to be something that the patent office is going to have to issue further guidance on. There'll be cases that are decided by the Patent Board of Appeals. There'll be cases decided by the courts and the Federal Circuit, which is the court of last resort of patent law appeals. So this will all have to play out. But the, I guess, good news is that you can protect inventions that were created by AI in certain circumstances, standard. So it's worth trying. Next slide. Now, copyright, as David says, big issue for AI and IP. So this is very different. Copyright law is very, very different from patent law. So copyright law actually, the Copyright Act itself talks about human authorship. All right, that's very important in this context. Machine authorship is not recognized in this country as giving rise to a copyrightable work. So if you do use AI to create substantially all of the content that you're using in whatever capacity, promotional or otherwise, consumer facing in particular, you're not going to be able to prevent other people from copying, because the machine created content is not by definition copyrightable. There has to be some human authorship. Now, human authorship does not mean, in this country anyway, the creation of prompts that are input into the AI system. Prompts are what you cue, whatever AI model you're using to create what you want to create. Give me some branding material using the colors blue and yellow that mention these things in this order, and include pictures of X, Y, and Z. So notwithstanding that you've given a fair degree of direction to the model, it's not sufficient if you end up using the output as it's generated, just exactly the way it's generated, or you really don't make substantial changes to it. So we can't protect that. You can't have exclusive rights in that. You can't register copyright in it. Now, another complicated question that has yet to be answered is what happens when the machine and the human being collaborate, and in such a way that it is impossible to really figure out what the human being did and what the machine did. And when there are two human authors, or more than two authors, when there are multiple collaborators and they contribute to each other's creative work in a way that makes it impossible to separate one's contribution from the other, then they both walk away with copyright. I often recommend collaboration agreements for this reason, so that it's clear what each party can do with the copyright, because without an agreement, each party can freely exploit without regard to the other's contribution. So when you're dealing with a joint work, you're typically dealing with an entire book that was written by two authors. Each was editing this example, but each is editing the other's contribution, so you can't tell who created what with respect to what chapter. A good example of a work that's not a joint work would be I write chapters 1 to 5, the other author writes chapters 6 through 10. It's clear one's copyrighted one. They're not merged. But who knows what happens when you have a machine and a human being? One would think the human being would walk away with the copyright in the entire work if there was a significant contribution, but we haven't had a case yet to establish this. So on the next slide, I'm going to talk about the first AI case that the Copyright Office ever dealt with, and it involved a comic book. Why should you care about a comic book? Because, in fact, the lessons that you can draw from this precedent are directly applicable to what you can register as copyrightable in your own machine human works. So in this particular situation involving the comic Diary of the Dawn, and we'll go to the next slide, the machine created the images that were used. So you just saw the heroine of the series Zarya, and she's totally machine created. And the author, the human being, created the text of the comic book, the selection and arrangement of the images, what the characters said. Again, no answer to the question of who owned what in this particular situation as far as a joint work, because you could easily separate the authorship of the machine from the authorship of the human being. So what did the Copyright Office decide? Well, it was its case. They determined the images were copyrightable, the selection and arrangement was copyrightable, what the character said and the text, all copyrightable. But the images had to be excluded, okay, from the scope of the copyright. Next slide. So it's really important for you to take away from this that you need to make a substantial human contribution to any AI content in order to protect that content. So you should be involving real people in the generation of, for example, advertising and promotional materials, logos. Okay. Next slide. So as I've alluded to, the models generally indiscriminately scrape publicly available data. Not surprisingly, a lot of this data is copyrightable. It's newspapers, websites, social media platforms. For example, Reddit was scraped without permission. Images, art, and photos of real people. And this creates an input-output problem. Garbage in, garbage out, same issue. Input is bad, output is going to be bad in terms of infringement risk and exposure. Next slide. So a really kind of fun case that illustrates the input-output problem is a case that was brought by the producer of Blade Runner, the movie, against Elon Musk, Tesla, and Universal. Elon Musk, in his typical fashion, when he couldn't get permission to use still shots from the movie to promote his Tesla Cybertruck, went ahead and did it anyway. He input the original image from the movie on the left and generated the image on the right. As you can see, there are substantial similarities between them. Then he got sued because he globally streamed this on Universal's lot. Universal got sued too. Tesla got sued too. Case is working its way through the courts. This is the perfect example of, you know, an actual intentional use of bad input to generate bad output. Next slide, please. So Reuters, New York Times has sued, Reddit sued, reached a settlement. It was paid hundreds of millions of dollars to allow AI to scrape its content. However, none of the people who actually created the content, the everyday users of Reddit, were consulted as part of this deal or compensated. There is supposed to be an opt-out for those people if they don't want their information to be scraped. Who knows if that's going to happen? Image generators have also been sued by artists. If you are not careful about how you prompt an AI, you could end up with a copyright infringement problem with an image. For example, you could ask any AI tool that's open to generate Elvis in the style of Andy Warhol, and you will get something that the Andy Warhol estate will not be happy about at all if you go ahead and commercially exploit it. So the lesson is that when there is no clearance of the content of the data set that goes in from an IP perspective, then what you're going to get out of it could be potentially infringing of third-party rights. Next slide. Another issue that arises frequently in respect of AI has to do with scraping people's images, voices, likenesses, anything that's a unique aspect of their persona that this is me. They've scraped my image, my voice. And in those situations, there's a right of publicity, which is sort of an IP adjacent right, which attaches to every individual. It's the right to use your own image, voice, likeness in connection with a commercial exploitation. So the deepfakes laws I've alluded to earlier are designed to help with this problem. That's at the state level. There's a law in Tennessee, which is humorously named the Elvis Act, because of course that's where Elvis is from. And it stands for the Ensuring Likeness, Voice, and Image Security. And that was really designed to protect celebrity likenesses. Importantly, right of publicity survives death in a number of states, including, not surprisingly, New York and California. So it doesn't matter if the person is dead. Elvis and Marilyn Monroe's estates are actively policing violations of the right of publicity. So if you're using AI, we do not recommend you generate images of people using AI. And by the way, the hallucination problem comes in here as well, that David alluded to earlier. Gemini got into huge trouble when a user was able to generate African American and American Indian founding fathers of the country, founding people of the country. That problem happened because Gemini was trying to balance for diversity and inclusion and equity and ended up overcorrecting for the problem. And that was terribly embarrassing for the AI platform and, potentially disastrous for anybody using the images. Another way that AI can be used is to replicate voices. There have been several lawsuits by voice actors whose voices were used for different purposes from what they were told. There was also a famous case involving Scarlett Johansson, who you may recall was the voice of the computer in Her, voice of the AI system in Her, and whose voice was replicated for the purpose of being OpenAI's voice. Scarlett Johansson was not happy about this. She threatened to sue, and OpenAI pulled the voice. Next slide. Somebody has asked the question about what is the degree of risk that you're facing? Well, the degree of risk you're facing has everything to do with what you do to mitigate that risk, because there's definitely, a high volume of content, and people do enforce their rights. So it's very much on people's radar right now. So I would say that, give me a minute, I'll be going through risk mitigation in just a bit. We only have a few slides left. So the same way that you can run into problems with copyright, you can also run into problems with brands. You use the AI to generate the brands. You may end up with a third party's brand you didn't know about. This is why clearance, trademark clearance is so important. Just as you do trademark clearance when you generate an idea on your own as a human being, you want to do clearance when it's machine generated. It's even more compelling case for clearance when machine generated your brands or logos. And by the way, logos can be subject to multiple forms of protection. You can have a trademark for a logo, and you may be able to even have a copyright for the logo. So for very flat, or it's on print, or other types of fabric designs and other kinds of more creative IP trademarks can be subject to copyright as well. So you can end up with a logo that infringes not just trademarks, but copyright. The next slide, please. So when you're licensing AI to avoid the kind of leakage problems that we talked about earlier, you want a system that has zero retention. So that means that none of your input or what you get output is used to train other models, and it's not retained by the service provider or host. So it's solely yours, not being used by anybody else, because it's not in the system, zero retention. You also want a service provider or on-premise host to make sure that it's not accessible to others' users or to the host itself. So none of this input or output will be accessible to your service provider. And finally, you want to make sure that the quality of the tool you're getting isn't just sort of a curated tool that's publicly available where it was pre-fed prompts so that it would have a specific data set, but it's not really proprietary or closed, that you're actually getting value for your money and you're getting a tool that was bespoke and has only data input into it that is valuable to you. Next slide. So how do we mitigate risk? Trademark clearance, which I mentioned, you've got to read the terms and conditions, those things that everyone clicks through on everything these days, from apps, websites, everywhere. Those terms of use and conditions are particularly critical because you want to see that that platform is telling you we have a clean data set, and we are sure we have a clean data set because we are going to represent and warrant it and indemnify you if you use any of if you use our platform and any output is allegedly violative of third-party rights. We'll defend the lawsuit, we'll pay any damages. That's what you really want. You want a provider that is standing behind the content. Now, reputation matters, of course, but the newer platforms are probably in better shape than the older ones because there's an increased sensitivity given all the lawsuits that have been out there to licensing. So now there's a great deal, there are many providers of everything from music to content and images that are clearing rights, that are making sure that they have the rights to give to you to generate content based on their data set. So that is something newer platforms are in a better position to do because they can address it prospectively, whereas what's happening with the older platforms that are getting sued, it's kind of a Band-Aid approach. They're going, whoever sues them, they're going back and retroactively licensing, like in the Reddit case, but they're not going to do that for everything. So what's more, you can reduce the hallucination problem if you have a good data set. You can also be careful of your prompts. You don't want to use any well-known brands or people's names or artists' names, or don't generate a portrait of me in the style of Picasso or a portrait of our CEO in the style of Andy Warhol. You don't want to do those kinds of things because it's obviously going to lead to problems. And also don't do what Elon Musk did. Don't put in original, say, oh, I really like the look and feel of this film or this ad or this novel passage in this novel. Don't input that in because the likelihood is you're going to get something substantially similar or derivative out. And remember, adaptations of original works, that right to adapt is the copyright owner's. It's not your right. Next slide. Okay, so I think we just managed maybe to go 2 minutes over, but here's where you can connect with us on LinkedIn. And here's where you can subscribe to our blog, which often has information about AI because it's a rapidly changing landscape. And if you did have questions that weren't answered, it looks like there are no open questions, please, or something occurs to you later, please feel free to reach out to either of us. Here are our email addresses. We'll be following up with all of you. We'll be providing the PowerPoint. There will be a video recording at some point posted to YouTube. So thank you so much for taking time out of your day to join us. Take care. Bye-bye.